Well, a very good morning, everyone, and welcome to the first of our webinars for Charities for 2021. You won't need me to remind you, I'm sure, that it's been a very challenging year this past year. Many struggling charities for income and also with demand for their services increasing. And so the point of this seminar as we start this new year is to help you think through some important issues that may be important as you face this coming year in terms of how you plan and deal with those financial and other challenges. In a moment, I'm going to hand over to my colleagues, Adam McRae-Taylor and Olivia Stanton, who are employment lawyers within our charities team. They will be giving the bulk of this morning's presentation, and I will come back at the end for just a few thoughts on mergers and collaborations. After the formal presentation, there'll be time for Q&A, and you'll see a Q&A button at the bottom of your screen. Please do that to log your questions as we go through, and we'll get to them at the end. So the next slide will give us a view of the contents and the topics we'll be covering over the next 35 minutes or so. And after that, we'll hand over to Adam to kick off proceedings. Adam, thank you very much.
And hopefully you can see that on the screen. So perhaps nothing illustrates the changing nature of the last year that we have faced, quite like the furlough scheme. So if you can cast your minds back to March 2020, that was when the furlough scheme first came to be with us. And back then it was a case of the government reimbursing 80% of salaries up to £2,500. At that point, the government was still covering national insurance, employers' national insurance contributions, and also minimum auto-enrolment pension contributions. And then in the summer, the scheme evolved in July to add on this concept of flexible furlough, where it would be possible for an employee to work part of their hours, but nonetheless, when they weren't working, still be reimbursed under the furlough scheme. And that part of flexible furlough has continued with this extended scheme. However, at this point, the government has said that employers must pay the employer's national insurance and pension contributions. Other key developments that have happened in the last month or two, the job retention bonus, which was originally going to be £1,000 for each employee, kept on until January. That has been withdrawn. Similarly, the old concept of the job support scheme, which was meant to come in for viable jobs when hopefully we were meant to be turning the corner and the furlough scheme was meant to be being phased out, that is gone. And so now we're with this extended furlough scheme until the end of April. Another new development is that from February, HMRC will be publishing details of claims made under the scheme on the internet. And this is part of a general drive to crack down on so-called furlough fraud. So obviously the scheme was implemented very quickly, and now HMRC is working through thousands of cases where it thinks that there might have been serious error, and it's looking to chase down people it feels may have abused the scheme. It's also been issuing several thousand what are called nudge letters a week, where it writes to an employer and says, we think maybe your calculations might not be quite right under the furlough scheme. Would you mind checking them and seeing if you think that they're correct? So there is a general drive towards making sure that people are using the scheme properly. And that perhaps fits into sort of its evolving rationale or purpose. So initially, when the scheme first came in, employers wondered, well, do we have to be only using it for people who would otherwise be made redundant? And then it became clear that that wasn't actually the case, and it was a more general purpose. But the government is now saying that the scheme should be accessed by employers whose operations have been severely affected by coronavirus. And this is important for the purpose of retaining those employees. So what this means is there's still a sort of a broad discretion that employers have in terms of deciding whether or not to access the scheme. But it really ought to only be for employees who you're trying to retain, who you probably otherwise would lose. And Olivia's going to talk a bit more about redundancy in a moment. That raises a tension where employers are doing redundancy exercises, and staff will naturally say, well, you could put us on furlough until the end of April, and employers have to weigh up as to whether or not that is the right thing to do. Probably the other key point to be aware of that has changed relatively recently is that of notice pay. And previously, employers could claim notice pay under the scheme, but since the 1st of December last year, that has no longer been possible. And this all fits into the rationale for the scheme, which is it's designed to retain employees and encourage employers to hang on to employees as long as possible. Obviously, we're in another national lockdown at the moment, and so the number of people on furlough will have risen quite significantly. The government has explicitly said that clinically extremely vulnerable staff who cannot work from home can use the furlough scheme. Contrast that with the clinically vulnerable, whom the current guidance is that if they take appropriate precautions and their job has to be done in person, so out of their home, they could still safely go to work, and so the furlough scheme probably wouldn't be appropriate for them. The government's also said that people with caring responsibilities, so people who got to do childcare unexpectedly, for instance, who couldn't work effectively from home, they could also be placed on furlough. So that's a quick run through the furlough scheme. I'm sure there'll be questions on it in the Q&A. And at this point, I'm going to hand over to Olivia.
So redundancies are an issue that charities are more and more having to turn their attention to. The impact of the coronavirus on the economy has meant that lots of people are on furlough, people have had to take pay cuts, people are losing their jobs. And the result of this on charities is that people have less disposable income from which to donate to charity, which I'm sure you are very aware of has meant that charities have shrinking budgets and they are having to make difficult decisions. And how a charity approaches a redundancy situation says a lot about your values as a charity. And you also never know when you're going to be crossing paths again with someone that you make redundant. So it is important that from the outset, you're looking at carrying out an open and thorough redundancy consultation process. So as a starting point, I wanted to have a look at what actually is redundancy. And redundancy is a potentially fair reason to dismiss an employee, provided it is for a genuine redundancy situation and that you're following a fair process. So there are three types of redundancy situation. The first is the very unfortunate position that you are having to close your charity, or it may be that you're closing one of your charity's sites. Or the third situation, which is probably the most common one, is that there is a reduced requirement for employees to carry out work of a particular kind. And this will encompass the kind of situation where you're having to cut costs by reducing your headcount, or you're having a restructure to cut your costs, and as part of that, you're getting rid of a management level and everything's going to be carried out at a more junior level. And one of the key steps to getting your redundancy process right is going to be having a really sound business rationale. And so this is the document where you're going to explain why you need to make redundancies. And the more thorough and the more transparent you can be in this document, the greater understanding your employees are going to have of why you're having to go through this process. And redundancy is a fairly risky process. I think now more than ever, people are aware that the jobs market isn't a nice place to find yourself. And they realise that if they were to be made redundant, it might not be that straightforward to find another job. And if they're going to be out of work for a while, then they may be more inclined to bring a claim than they ordinarily would have been. So the main claim that needs to be on your radar is unfair dismissal. And an employee is most likely to claim this where they feel that there wasn't a genuine redundancy reason for you to start the process, or more commonly, they think that you didn't follow a fair redundancy process. You also need to be aware of potential discrimination claims. So this will be where someone claims that they were dismissed for having one of the 9 protected characteristics under the Equality Act, rather than it being a genuine redundancy dismissal. You should also be aware that there's a potential for a breach of contract claim if you have a contractual redundancy policy, or whistleblowing claims is the other one that we're currently seeing a few of. And this is where you're in a pandemic and your employee has raised health and safety concerns because they don't think that you've made your workplace COVID secure. Following this, they then get selected for redundancy. And there can be the argument that they were selected for redundancy because they raised those health and safety concerns. So these are just claims to have at the forefront of your mind when you're embarking on your redundancy process. The process can never be completely risk-free, but hopefully I'm going to run you through some of the common pitfalls and you can minimize those risks as far as you possibly can. So at the outset, you're going to look at, do you really need to make redundancies, or are there some alternatives you can consider? And you'll see on your screen, I've got some of the possible alternatives to redundancies that it's worth considering. And once you've thought about these, you might still decide that actually these aren't enough and your charity needs something a little bit more long-term than this in order to remain viable. And that's fine, but do just make sure you're documenting the fact that you have considered all these alternatives and the reasons why you've decided they're not suitable for your charity. So it's definitely worth, before you start out on your process, investing some time into planning exactly how your redundancy process is going to work. So the first question you want to ask yourself is, do you have a redundancy policy? And if so, what does it say? And you need to be making sure you're actually following what the policy says. The last thing you want is midway through the consultation, a clever employee discovering a redundancy policy that you'd forgotten about hidden at the back of your staff handbook. So the next thing to think about is who is going to be needed to carry out the process. So if your charity has an HR team, then I'd recommend having a couple of people from HR overseeing the process. But as well as that, you're going to need to think about, are there any line managers that are needed to put some input into the selection and scoring process that you're going to have to undertake? And are they on furlough? If so, you need to look at bringing those managers back from furlough. And it's also going to be worth thinking about who's going to hear any appeals and keeping someone high up in the charity back from the initial process so that they can hear those appeals impartially. You need to look at how many employees are going to be affected, and this is measured over a 90-day rolling period. So you need to look both back at redundancies you've already made, forward at any you might make, and if there's more than 20, then you'll need to be engaging in a collective consultation exercise, which I won't say any more about, as Adam's going to talk to you about that shortly. But just to say that the process I'm going to be speaking about is only applicable if you'll be making fewer than 20 members of staff redundant. You'll also need to think about, how are you going to conduct your consultation? So at the moment, it's very likely you're going to need to do this remotely. And what platform are you going to use to do that? And will employees be comfortable with that? So if most of your staff are office-based, then I'm sure they're very used to using computers. But if your charity has staff who are more involved in caring roles or in community-based roles, then they might not be that savvy with a computer. And so it's worth checking that they are happy doing it via Zoom or via Teams, and if not, giving them the option to do it by phone. And you'll finally want to think about, are you going to pay the statutory minimum redundancy pay, or are you going to offer an enhanced redundancy pay? And if you are going to offer an enhancement, then I would recommend you require your employees to enter into settlement agreements, which will mean that they are waiving their rights to bring any employment claims in exchange for that enhanced payment. And this is definitely something you should be taking advice on if that's the route you want to go down. So one of the biggest tasks that you're going to be undertaking in your redundancy process is pooling staff and then setting selection criteria by which you're going to provisionally select your staff for redundancy. And in pooling staff, there are no fixed rules, so you do have a large element of discretion, but you do need to make sure you're acting reasonably, and the pool should really contain employees who are broadly doing similar work to each other. And employees will often want to have a very wide pool, but I would recommend keeping it as narrow as is reasonably practicable, and really confining it to just the areas of your charity where you are making cuts. And in the pooling, I'd say really just take a common sense approach to this. So you're looking at, where are you making cuts, and what employees work in those areas where you are making cuts? And then, are there any other employees whose skills or duties are interchangeable with those employees who are in the pool? And quite a common question is, can you have a pool of one? And the answer is yes, provided you're acting reasonably and you are looking at whether there is someone else whose skills or duties could be interchangeable with that one employee in the pool. And if, having done that, you decide that actually there really is only one employee for this pool, then that's fine, but do make sure you are documenting your reasons and the process you've gone through in arriving at that decision. And one other thing to think about is bumping. And this is where you have a role that you're making redundant, but you want to keep the employee who's doing that role. So you move that employee to a safe role, and the employee who was previously in the safe role is in fact the one that's going to be at risk of redundancy. And so it's not something you have to consider, but it is open to you to do so if you would like to. So you've got your pool of employees, and now's the time when you've got to set the selection criteria that you're going to use to select the employees provisionally for redundancy. And you need to make sure this is clear and objective criteria. And I've got some examples up on the screen of criteria you might want to use. So there's performance and ability, length of service, attendance, disciplinary records. And as well as this, there might be other more specific criteria that's particularly relevant to your charity or to the areas of your charity where you're making redundancies. So you might want to look at ability to speak other languages, or networking ability, or marketing experience. And it's open to you to attach whatever weightings you want to particular criteria if there are certain aspects that are very important or less important to your charity. And one of the main areas where employers sometimes fall down is discrimination. You mustn't have discriminatory criteria. So you can't give an employee credit for being a full-time member of staff rather than a part-time member of staff. And you also should be aware that whilst length of service is something you can consider, it's one element you definitely can include, but the traditional approach of last in, first out is not something you should be relying exclusively on. So your more established members of staff may well be older than your new starters, so there is the potential there for that to be age discriminatory. And likewise, you need to make sure you're discounting any absences that are related to disability or pregnancy or maternity, as that would be discriminatory as well. So as far as possible, you want to make sure your criteria is measurable and supportable with clear records. So you're going to be looking at your disciplinary records, your attendance records, your appraisal records. And this really is a lesson for routinely maintaining good records and having robust appraisals, as not only will they be supporting your decisions here, but it ensures there aren't going to be any surprises when an employee suddenly scores badly in a redundancy selection. And when it comes to actually carrying out the selection scoring, a really good practice is to have 2 managers who separately go away and each individually score each employee who's in the pool. And this helps to ensure that there's less bias, less discrimination, as those managers then come together and jointly form a final scoring for that employee. And of course, if an employee is going to be provisionally selected for redundancy, in order to show you're following a transparent process, they should be given a copy of their scorings. So a fair consultation process is absolutely essential to ensuring that the redundancy is deemed to be fair. And you're going to want to look at having around 3 meetings in your process. So there'll be the initial at-risk meeting, and then a further couple of meetings with employees who are provisionally selected for redundancy. And at those meetings, you're going to want to be discussing the business case behind your decision to make redundancies. You're also going to want to look at how you formed the pool. You want to discuss your selection criteria, discuss the scorings that you've given. And this is really also an opportunity for employees to make their own representations and to ask any questions they might have. So when there are fewer than 20 employees, you do have quite a large discretion in how long to make the consultation process. There's no minimum, there's no maximum periods. But I would say in general, you want to be looking at 1 to 2 weeks as a minimum period in a more straightforward case, and up to 4 weeks in a more complicated case. And you want to make sure you're leaving sufficient time between all the meetings to allow employees to go away and digest the information you're giving them, prepare their submissions, and just make sure that they don't feel you're rushing the process. Now, there's no legal right to be accompanied at the consultation meetings. However, consultation meetings, they are a stressful experience for employees. So unless you have a particular reason why you don't want employees to be accompanied at their meetings, I would recommend offering them that right to be accompanied if they would like to take it. And you'll see I've also listed some of the key principles on the screen that it is helpful to bear in mind as you go through the consultation process. And keeping these at the forefront of your mind will just help to ensure that you are genuinely engaging with your employees in a meaningful consultation, that you're allowing them the opportunity to have their say, that you're keeping an open mind and making very clear throughout the process that this is still just an idea and no firm decisions have been made. It's essential in order to show that you have conducted a fair redundancy process that you can show you have made a search for suitable alternative employment. And this doesn't mean that you need to create any vacancies, and it doesn't mean that you have to exhaust every avenue, but you do need to be able to show that you have made reasonable efforts in your search for alternative employment. And I would recommend sending a list of vacancies through to the employees that have provisionally been selected for redundancy, and also just bearing in mind any potential future vacancies that might in the foreseeable future crop up, and keeping employees informed of these. So if having informed an employee of a possible vacancy, that employee says that they would like to apply for that vacancy, then you can hold a competitive interview process. And having held that competitive interview process, you can still decide that you don't want to offer the vacancy to that member of staff. If you are making that decision, then do document the reasons why you have arrived at that decision, as if you're going to be challenged in the future, that's going to be essential in showing why you made the decision not to offer that vacancy. The big exception to this rule is if an employee is on maternity leave, shared parental leave, or adoption leave, then that employee must be offered the vacancy. And that is regardless of whether there are other internal or external candidates who are better qualified, you must offer the vacancy to that employee. Should an employee be offered a vacancy and they take it, if the terms of that new role are different from the terms of the previous role, then that employee will automatically have a 4-week trial period. And this is the opportunity for both you and the employee to see if it really is a suitable vacancy, if it's working out, if it's something they want to continue with. And at the end of those 4 weeks, should either of you decide that actually this isn't really working out, then that employee is still made redundant and they will still be entitled to their statutory redundancy payment. So you've come to the end of your process and all employee questions have been answered. You have completed your search for suitable alternative vacancies. At this stage, you can now confirm the redundancy. And it's best practice to do this in person in a meeting with the employee and to then follow this up in writing. And in that letter to the employee, you must make sure you're informing them of their right to appeal the redundancy. And you should also be setting out how you have calculated their statutory redundancy payment, as it is an offence not to provide the information on that calculation. And as a final point, when you are going through your process, just remember to retain the human element to the process. We're in a pandemic and a lot of people have a lot of things going on at the moment, and redundancy processes are stressful for employees. So do just bear in mind what extra support can you give to your staff, and that might take the form of redundancy support or help with their CV, anything like that. Think about what you can do to make things a little bit easier for them. And finally, if you are going through the process and if you are in doubt about anything, then do seek some advice, as it is so much easier to prevent a problem from occurring than to wait for the problem to have occurred and then have to try to go back and fix it. So do try and nip that in the bud from the outset. So I'm now going to hand over to Adam, who's going to explain to you how this process would be different if there were more than 20 employees who are at risk of redundancy.
Well, thank you very much, Olivia. I have successfully managed to unmute myself this time, so we're doing better. So Olivia has helpfully worked through the process where you have fewer than 20 employees, where you follow a standard redundancy consultation process. But the key thing, which I'm sure many of you know, is that if 20 or more members of your organisation are at risk of redundancy, then everything changes and you need to have a collective consultation. And it's worth saying at the outset that this 20 or more rule can catch quite a lot of different types of restructure. So it will obviously encompass situations where 20 members of staff or more are about to lose their jobs potentially. But it can also cover, for instance, changes to terms and conditions, pay cuts, which will be another of those. And that's because often when employers are trying to push through changes to terms and conditions, such as, changing pension maybe, the way that's done is with what's called a dismissal and re-engagement process, where there's a consultation and then staff are given a contract variation to sign. But if they don't sign that variation, then they'll be given notice of dismissal and then an offer of a new job on those new terms to take effect immediately after the notice has expired. So this is called dismissal and re-engagement, and technically it counts as a redundancy for the purposes of the collective consultation rules. So it has a very wide interpretation. So always be thinking, does this 20 or more rule apply? If it does, then that means that you've got a minimum 30-day consultation period if 20 to 99 employees are at risk, and a minimum 45-day consultation period if 100 or more employees are at risk. And that period, that 30 or 45-day period, has to elapse before the notices of dismissal are given. Now, the consultation again changes, because this time it has to be with either trade union representatives if you have a recognised trade union. More likely you won't, and so you'll have to elect employee representatives with whom you conduct the consultation. So at this point, your legal consultation duty is to consult through the representatives, and the representatives will act as a conduit between you and the members of staff as you communicate your proposals. And you would usually envisage having several consultation meetings through that 30-day or 45-day period, in which you explain your proposals, take on feedback from the employees through the representatives, and so on. Another important thing to bear in mind, sometimes forgotten, is that you also have to notify the Secretary of State when there are 20 or more employees at risk of dismissal. You have to use an HR1 form. It's a very simple form, only a couple of pages, but it has to be sent, and it also needs to be copied to the representatives. And these are just some general tips on consultation more widely with employee reps. Olivia's given lots of excellent principles already about how to conduct consultation. And I think where sort of large-scale redundancies are proposed, the transparency point is really key. So it will be expected that quite detailed financial strategic information is disclosed that would justify taking the steps of making that many people redundant. So, you know, if you're a school, we've got lots of schools on today, as well as normal charities. Governors would be preparing a business case, or charity leaders would be preparing a briefing paper setting out in detail why these proposals are necessary. Usually there would be a big all-staff meeting at the beginning of the process to explain why we've got to this situation, what is necessary. And this is all really part of the process of bringing staff on board, persuading them that this difficult course of action is necessary. Also talked about time. Obviously, there are those statutory time limits that you've got to comply with, but also any sort of suggestion that you're rushing a process through will count against you. So it's definitely worth taking a little bit of extra time to get the process right, to engage with all the questions that come up, so that you can take staff with you as much as is possible in a difficult situation. And that feeds into the next point about engagement. And you know, we talked about support through HR, employee assistance, and that kind of thing. As Olivia notes, this is a really difficult time. We really need to be as sensitive as possible in approaching any redundancy situation right now. So we've been talking about redundancies, restructures more widely, and one specific type of restructuring is mergers or collaborations with other charities. And I'm going to pass on to Gordon, who's just going to talk a little bit about those.
Adam, thank you very much. Just a few minutes from me on the subject of merger and collaboration. Mergers the word merger has been in the charity world for a while. The Charity Commission itself, I think, thinks there are too many charities in England and Wales, and there are too many doing the same thing, perhaps quite a lot of small ones doing the same thing. Could they be more effective if they were to merge? And obviously, with the financial pressures of the current climate, that sort of conversation has come up the agenda, or maybe needs to come onto the agenda for your charity as something you should at least think about. And that could perhaps take a couple of forms. You might think about collaboration arrangements with other charities. You might think about a more formal merger. Collaboration really can cover a number of forms. You might just decide to get together with another charity to share a particular project, which would mean that you could share the resourcing costs, you could share premises costs when you're once again allowed to run projects from premises. You just might be able to make some savings and be just as effective as you would have been had you been running the project on your own, if you've got a charity close to you who is involved in the same area, trying to reach the same sort of beneficiaries as you yourself. The key really with all of these things, with any decision you make as charity trustees, as leaders, is what's in the best interests of your charity and its beneficiaries. And that doesn't mean just in the next 2, 3, 4, 5 months. It means longer term. How can you best secure the future and longevity of your charity? So collaboration, thinking about the ways in which you might work with other charities. And it's just really important, and you probably would expect a lawyer to say this, but it's really important that you pin down what you're actually agreeing with that other organisation. Who is doing what, who's contributing what by way of resources, what the outcomes you're seeking to achieve are through this collaboration, how long it's going to last for, how it's going to come to an end, and if there are any issues which arise along the way, how you're going to resolve them. The temptation is always, you think this would be a fantastic idea, I'm having a really good, useful conversation with my opposite number in this other charity. What could possibly go wrong? And hopefully 99 times out of 100, nothing will go wrong. But we see problems arising. And as Olivia said in her context, if you actually just take a little bit of time and put a little bit of legwork in before you start, you can usually head off the problems that might otherwise arise if no thought is given to those issues. So just a plea that you consider pinning down those issues and making sure you get advice if you need it, to make sure you do it in the right way and protect your charity's interests as well. And then merger, just 1, 2 or more charities coming together on a permanent basis. There are 2 or 3 ways you can approach that. You might decide that if there are 2 charities of really equal stature, equal standing in their community, then actually the best way to do it, to show there's no inequality in the merger process, is to set up a new entity, a brand new charitable entity into which those organisations can merge, and then you've got that whole new launch of that new entity, and there's no sense of one organisation being taken over by the other, which is sometimes important in the eyes of donors or indeed in the eyes of beneficiaries. So that's one route. But probably the more common route is you have 2 charities, perhaps one is slightly larger than the other, and there is a merger into that larger entity. The smaller entity that's merging simply transfers all of its assets and all of its liabilities into the organisation, and that's going to be carried forward, and that one merged entity carries on, and in the fullness of time the charity which has merged into it is wound up and removed from the register of charities. That's probably the simplest way of doing it, certainly the most time effective, because if you go with the route I mentioned to start with, you have to set up a new charity. That involves an application, a registration process with the Charity Commission. And although, bizarrely enough, through the pandemic, response times seem to have improved at the Charity Commission, it is something of an unknown quantity as to how long how long it's going to take to procure a registration of a new charity. The appropriate structure you alight on will depend on the circumstances you face, and as I say, on your timescale. Bear in mind too that there may need to be changes to your governing document to allow you to give effect to a merger with the charity which you've identified as a potential partner. There are plenty of pitfalls on the merger process, and my plea to you would be to seek advice early if you're considering it, so you can get all your ducks in a row in an ordered way and be able to progress conversations, perhaps with your opposite number as a CEO, your opposite number as chair of trustees, or just a number of trustees getting together thinking, actually, this is a really good idea because we can be far more effective with the use of our charity's resources than we would be if we kept on ploughing our own individual furrow. as I said at the beginning, the best interest of the charity is one of the golden rules of the way in which you make decisions about how you carry on for the future, how you plan for the future. And as I say, I think it's prudent to have merger on your radar, even if you decide now is not the time or there isn't an appropriate partner. It may be appropriate a year down the line. So just to keep it on the radar as a sensible course to be considering at some point should the need arise, either strategically or because the financial pressures, the financial challenges are such that it really has become a necessity. I think that's all I'm going to say about that for now. We did want to leave plenty of time for questions, and so I will stop that bit of the presentation and move on to some questions. I see there have been lots of questions coming in as we've been going through the presentation, so I will bring those questions up, and most of them, I think, seem to relate to the topics that Adam and Olivia have covered. So I'll leave it to them to fight over who answers the questions. But let me start with this particular question. If an employee who is potentially in the pool for redundancy is on maternity leave, what additional rights do they have or precautions should we consider?
Yes, so I think the big thing you have to be aware of with employees on maternity leave is the issue relating to suitable alternative vacancies. So a member of staff who's been on maternity leave must be offered a suitable alternative vacancy, regardless of whether the fact of there's another potential applicant who is better qualified for the role. But in addition to this, you also need to be considering how are you going to be engaging a member of staff who's away from the office on maternity leave in the redundancy process. And so you have exactly the same obligations to consult with that member of staff. And I'd say just really be very flexible in how you do this. So that member of staff, they've just had a baby, they've got lots of other commitments at home going on. So see how they would like to be consulted with. And this may well involve going out to visit this member of staff at home, or if they are going to be coming into the office for their meetings, you might want to consider, do you want to let them bring the baby in with them? Whatever it takes to make them feel comfortable participating in the process. And do just make sure you're keeping them as informed with what's going on as you are all the other members of staff in the redundancy process, and that you're not letting them that you're not forgetting about them because they aren't physically there in the office with your other members of staff.
Yeah, thanks very much, Olivia. Sorry, Adam.
Absolutely right. Just to jump in and add something on that. Olivia has drawn our attention to the key thing, which is that pregnant employees have first choice on suitable alternatives. It's worth knowing that there are proposals in Parliament to strengthen those protections even further. Effectively prevent the various proposals floating around, but to extend the period where this protection exists into pregnancy and not just being on maternity leave, or to expand it so that pregnant or employees on maternity leave wouldn't be able to be made redundant at all. So just watch this space, because the rules could be tightened up even more.
Okay, thank you, Adam. Still on the subject then of redundancy, and in this case, the trial period for alternative employment. Does either party have the right to say it has worked or not? What if the employer thinks it's been good and worked well, but the staff member wants a redundancy payment?
So it's open to either party to say that they don't believe the trial period is working. So yeah, either the member of staff or the employer can make the decision that this trial period hasn't worked. And if that is the case, then the employment is considered terminated as at the original date when it would have been terminated, but for the trial period, and that member of staff will be entitled to a statutory redundancy payment.
Okay, thank you. And still on the subject of redundancy, a popular one this morning, what should we do if employees ask to see the scorings for other members of staff from the redundancy selection process?
Yeah, so this is something that staff often do ask to see. They're given their scorings and they think they're a great employee, and they see their scorings and they're told, oh, you're selected, and they want to know, well, how can I be? What did everyone else score as? And I think it's worth saying there's no obligation on you as an employer to show that member of staff, other members of staff scorings, and you certainly have to be wary of your data protection obligations. You shouldn't just be handing out these other scores, but you can certainly let staff know where they rank in relation to other members of staff, and you could also consider anonymising other scorings before showing them to that member of staff. You may want to wait for staff to really push for that if you want to do it, but it would help. It helps prevent challenges and shows that you've been as transparent and as open as you can reasonably be in the process.
Okay, thank you very much. And one more on redundancy. If you've agreed to a flexible working request after maternity leave, but then decide you want to make that person redundant, is that option open to you?
Adam, do you have anything to add on this one? That's quite a tricky situation.
Yeah, I think the answer is, yes, you can. So what I suppose the starting point is to say that once the person has come back from maternity leave, they're outside of what's called the sort of protected period, which is where a lot of these sorts of extra protections apply initially. But then I suppose the question is, why do you want to make the person redundant? Is it because there has been a genuine sort of reduction in the requirement for their services, in which case it would be a legitimate redundancy and you would just go down the sort of the normal consultation process? But if it's because you think that the flexible working thing isn't working out particularly well for whatever reason, potentially you might be starting to look at some discrimination issues. So it's worth sort of, is this a genuine redundancy in that there's less requirement for this employee's particular type of work, or is it something linked to the flexible working request, in which case a lot more care is going to be needed because various types of discrimination might be in play, things like indirect sex discrimination and so on. So take some advice, definitely, I would say.
Okay, we'll move now to furlough, or the overlap between furlough and redundancy. As a school during lockdown, we estimate that the average decrease in teachers' contractual obligations is around 33%. The school's finances will also be significantly hit by the loss of all boarding income. We would like to use flexible furlough for most of our teachers rather than to pursue a redundancy process to cover this shortfall, as we'll need the staff back up at the end of lockdown after all. Can we do this?
Yeah, and I think the answer is, I think yes. So the key thing is are your operations severely affected? And clearly the answer is yes, because the schools, the question says the school's finances have been significantly hit by the loss of boarding income. So I think yes, you've been severely affected. And then is the purpose to retain these members of staff? Well, I imagine the aim is that once life gets back to normal and boarding income is restored, that you would hope that you'd be able to keep all those staff and go back more or less to how things were before. So I think absolutely that is within the specific stated intention of the scheme by the government. And flexible furlough is designed to cover these sorts of situations where there is less work, but there is still some work, and to ensure that you've got the top-up payment from the government to keep you going through this difficult period. So yes, that strikes me as being exactly within the spirit of the scheme.
Okay, thank you, Adam. We'll take a break from redundancy and furlough into the charity side of things. Someone has asked what sorts of situations might require a change to the governing document if you're thinking either about a collaboration with another charity or a merger. I mentioned that in passing. And the answer is really, it depends on what you're contemplating. So if, for example, you think you might want to embark on a merger with another charity, you need first of all to see if you have the power to merge, because you can only do what you have the power to do under your governing document. And if you don't have a power to merge, then you must first give yourself a power to merge before you can embark on that. You may have a wonderfully widely drawn set of powers which allow you to do anything which you think is conducive to achieving the charity's objects, in which case you're probably covered by that. But if you don't have that and you don't have a specific power, then you would need to look to amend your governing document in accordance with the process outlined in it, or if you're a limited company, the process under the Companies Act for changing articles. So that's one thing you need to look at. Do you have the power to do what you're contemplating? You don't need the Commission's consent to make that sort of change, but you would need to make sure you've made the change before you embark on what you're seeking to do. The more crucial one perhaps would be your charity's objects. So if you're thinking of merging with another charity and your objects aren't exactly on all fours, then there could be some complications along the way if you end up with separate objects, because you merge with another charity and your objects are different. Then the funds you bring to the merger would still be restricted and could only be used for the purposes of your part of the new merged entity, which probably isn't going to be ideal. So you may need to look at changing your objects, and you will certainly need consent from the Commission to change your objects. So it is worth either dealing with that as a charity before you embark on the merger process and getting everything sorted so it's nice and tidy for the merged entity. You could, in theory, I suppose, leave it till afterwards, but that brings some complications, as I've said. So generally speaking, have a look at your governing document as you look at these things. If you haven't ever looked at it, or you haven't looked at it for a long, long time, it's always worthwhile dragging it out of the cupboard just to refresh your memory, but especially when you have these sort of things in mind, do make sure that you check that first, and if in doubt, seek advice. A couple more questions on furlough. If we don't want to bring staff back from furlough, can we make them redundant?
Yes, you can. I suppose, though, that stepping back from that, the question then is, should you be using the furlough scheme? Should you be using the furlough scheme now if staff are going to be made redundant in the future? So the idea of the scheme is very much now to retain staff that otherwise you would be losing because of the way you've been affected by coronavirus. So if it's simply a case of you know that there's really no hope of you ever being able to bring these staff back, and you're just keeping them on furlough for another three months or so and using the furlough scheme as a sort of welfare, extended option, that is not really probably an appropriate use of the scheme. So I think absolutely you always have the right to make staff on furlough redundant at any time. The scheme now doesn't cover notice periods, but if you're going to continue using the scheme, I think there needs to be some sort of realistic or some measure of hope that the staff might come back some point in the future.
Thanks, Adam. Just to say that we're due to finish the webinar at midday, so you do still, I've got a couple more questions to come, particularly for Adam on the furlough scheme, but if you do still have a burning question, you do still have time to post it, so do get busy with your Q&A box, and we'll try and cover it or cover them before we finish proceedings. But one which invites Adam to get out his crystal ball, and how long will the furlough scheme continue?
Yeah, I mean, it is a crystal ball type of question. I mean, I think that essentially that the government obviously would like to wrap up the furlough scheme. It's clearly it's tried to do that already. So it was going to try and phase it out by the end of October and introduce this sort of less generous job support scheme, which was only going to give some limited support to viable jobs. And obviously the second wave overtook things. You know, and again, actually, when the government introduced the extended furlough scheme sort of late in the autumn, the aim was that actually it would be reviewed in January and potentially sort of taper down again. So last autumn it went 80%, 70%, 60%. And, you know, I don't think that's going to happen anytime soon, obviously, because, you know, we're in a national lockdown. But I think that's probably the government's aim over the coming months, to steadily reduce the level of support under the scheme with a view to withdrawing it completely. So I don't think it will suddenly sort of go cold turkey and completely stop the scheme. When will that happen? Obviously, we've extended to April. We could easily extend again. And clearly a lot's going to depend on vaccines and whether or not we're able to safely sort of reopen. So, I mean, the best educated guess, I guess, is that, you know, we're going to sort of slowly phase it down through spring into summer. But we'll just wait and see.
Adam, thank you very much. And then one more for you. If a staff member on furlough refuses to come back to work because she is afraid of catching COVID, are you allowed to make her redundant?
Yeah, so it sounds like this is where you've ended the furlough arrangement, and so it's sort of back to normal working practices. And then it's a case of sort of working through, well, a number of questions, really. So first of all, does she have any health conditions? So is she clinically extremely vulnerable? The current advice is that clinically extremely vulnerable people should not be physically attending work. So the first question we need to explore is, can this person work effectively from home? If they can, that's probably the starting point for them. If they're clinically vulnerable, then they could potentially be required to provide services, you know, in person, in contact with others. If that's what's required and they can't do it at home. I think another sort of question that we need to explore is, this person's anxious of catching COVID. Is there an anxiety condition in play? So mental health conditions, including anxiety, at a certain threshold of seriousness can be classed as disabilities, which means we need to look at questions like what reasonable adjustments could be made, and so on. So the starting point probably isn't redundancy, because actually, you know, the question is, can this person there hasn't been a diminution of requirement for their services, it sounds like. It's more the case that they don't want to attend for work that is there to be done. So it's exploring whether or not that staff member can work from home, any reasonable adjustments that are in place. And actually, if you hit a complete impasse and it was reasonable for you to require that employee to attend work, then actually probably the disciplinary process would be the place to start. But I must emphasize that's really not where you want to go anytime quickly. That would be only after exploring all options and if a staff member continued unreasonably to refuse to work.
Adam, thank you very much. Well, our time is almost gone, and I think we've covered all the questions that have been asked, apart from a couple which relate to something I'm going to cover in just a moment. So we'll draw proceedings to a close. A couple of people have asked if it's going to be possible to have the slides, or if it would be possible to have a recording, and the answer to both those questions is yes. We will be sending slides and a copy of the recording out just after the event. In fact, we can't, the wonders of Zoom mean you can't send a recording out until 24 hours after the event. So it'll be tomorrow before we're actually able to send out the slides and the recording, but that will be coming out to you sometime in the course of tomorrow, we hope. And if you haven't received anything by close of play tomorrow, then do shout, and we'll try and sort that out. But thank you very much for joining us this morning. I hope it's been useful for you. I hope you benefited from the presentation, to give you some food for thought, and we're here to follow up if you need us. This is the first of a series of 4 webinars we're doing in the coming months. So we regroup with a slightly different team from our end. I think it's on the 25th of February when we're going to be looking at trustees' duties and responsibilities. We will be delighted to see you or your colleagues on that seminar. We'll be sending a reminder, details about that, about a couple of weeks before the event. But thank you very much for joining us. I hope you have a good rest of your day.